Good morning, everybody. Thank you very much for joining us, for being here this morning. Glad we have a good turnout for an interesting topic. I'm also happy to see a lot of new faces and some old friends, like my friend Eduardo from Peru. And it's great to see you here. And I think we have a great group to talk about an important issue. We're going to talk about the Trans-Pacific Partnership, the trade agreement that negotiators finalized on October 5th after 7 years of talks. More specifically, this morning we're going to focus on the investor-state dispute settlement process within the context of the TPP and what that means for a range of stakeholders. Long before the negotiations from the 12 nations in the TPP concluded their talks this year, the trade agreement has drawn public attention for the ways investor-state disputes will be settled. Businesses have sought protection for international investments as trade expands into new markets, which is a key goal of the TPP. At the same time, critics say arbitration mechanisms such as the ISDS sacrifice the public interest and give the upper hand to foreign investors, subjecting sovereign governments to decisions made by a handful of arbitrators in suits instead of local law. The issue over ISDS and the TPP has been debated in op-eds in major newspapers and white papers issued by both proponents and critics of the TPP. This morning we have a well-informed group to get into some of the details of the various clauses in the text, but I hope we can also step back and take a broader view of this issue. What's behind the controversy over the ISDS and TPP? Have negotiators struck the right balance between sovereign authority and protection for investors in the TPP? What are the implications of this for the countries in the Americas, and how could the arbitration process be improved? And we're really grateful that we have a superb group of experts to address these issues and these questions this morning, and then we'll invite your comments and questions as well. Jonathan Hamilton is a good friend of the dialogue, spoke here a couple of years ago about the International Center for the Settlement of Investment Disputes, the World Bank's arbitration body. He's a partner at White & Case, where he heads the firm's Latin America's arbitration practice. Jonathan's provided counsel on high-profile cases in recent years, including the cultural patrimony of Machu Picchu and the New Ecuador International Airport, some other issues as well the development of the Peruvian energy sector and the current expansion of the Panama Canal. He also serves on the board of advisors of our weekly energy advisor publications. I want to thank Jonathan very much for joining us this morning and sharing his thoughts. Jonathan will be followed by Clara Brimmenberg, who's a longtime friend also of the dialogue. It's great to see Clara here. She's a partner at Foley Hoag in Washington and has extensive experience representing sovereigns in investment arbitrations before the SID and other prominent arbitration fora. She currently represents Uruguay in the arbitration brought by Philip Morris challenging the state's tobacco control regulations. And Clara will be followed by Melissa Bluesky, who has joined us as well, and we're delighted to have Melissa with us. She is a staff attorney at the Center for International Environmental Law in Washington, where she leads the organization's People, Land, and Resources program. She has her law degree from American University, and she also has extensive professional experience as well, having worked in many organizations, including the United Nations and other private companies as well. So we have a great group of speakers, and I see in this room a lot of people with a lot of expertise and interest in this issue. So I'm going to ask Jonathan to start us off for about 10 minutes or so, and then followed by the other speakers, and then we'll open it up to all of you. Thank you again for coming. It's great to have this issue, I think, aired in a public forum. And before turning it over to Jonathan, I do want to thank my colleague Eric Brand, who is the director of our corporate program at the Dialogue, and Eric is really the person mainly responsible for coordinating and managing and organizing this program this morning. So I want to thank Eric for his support and for all of his hard work in this effort. So Jonathan, we'll turn it over to you. Thank you.
Thank you very much, Michael. Thank you also to Eric Brand, my co-panelist, and the Inter-American Dialogue. As Michael said, I'm Jonathan Hamilton. I'm partner and head of Latin American arbitration with the global law firm of White & Case. 25 years ago, there were no free trade agreements in the Americas. And within a very short period of years at that time, dozens of such treaties were ratified on a bilateral basis, with NAFTA on a trilateral basis, and you saw a real sea change in the approach or potential approach to managing trade and investment relationships among countries in the Americas. So much so was the consensus with respect to macroeconomic policy and free markets 20 years ago that there was a dream of the free trade agreement of the Americas, which has never come to fruition, but you might say that the Trans-Pacific Partnership is a form of free trade agreement of the Americas finally coming to fruition. What has happened during that interceding two-decade period, and what does that mean in terms of our understanding of the Trans-Pacific Partnership, what it means for the Americas, and in particular with respect to investor-state dispute settlement mechanisms? Whereas there was a significant consensus in the region 20 years ago, what we've seen over the past decade is significant fragmentation. We have seen a great deal of attention focused, including here at the Dialogue, understandably, on the emergence of Hugo Chavez and what Chavismo has meant for Venezuela and for the region. We've seen a focus on Evo Morales, a focus on Rafael Correa. Those are countries that followed, you might say, traditional cycles of Latin American history, which is there was a change in government, new constitutions, and once again a turn of the wheel in the long-standing cycle of rotation between who controls natural resources, who controls the economy. Nationalization, privatization, repeat. And we've seen that play out in certain countries in the region, reflecting a significant and utter fragmentation of the consensus that broadly existed 2 decades ago. And concomitant with those changes, we have also seen an effort by those countries, in some instances others, to pull back from the treaty system that was put into place in the 1990s. In some ways, you might think of the free trade agreements put into place in the 1990s as a new block, perhaps, on the cycle of history that we've witnessed play out over so long in the region. It was a step taken by states to say, we're going to, in some ways, like Ulysses, bind ourselves to the mast and tell investors and tell our people and handle our governmental planning in a way that focuses on long-term macroeconomic stability. So if you look at how things have played out from a policy standpoint, we've seen Venezuela, Bolivia, Ecuador denounce investor-state arbitration, complain about investor-state arbitration, pull back from investor-state arbitration, denounce the World Bank Arbitration Treaty. Meanwhile, although somewhat more quietly, you might say, other countries have stayed the course from the 1990s. They've stayed the course of ratifying more free trade agreements, of expanding free trade agreements, as shown, as far as the U.S. is concerned, through CAFTA, through the agreements with Peru, Chile, maintaining NAFTA, Panama, Colombia. I could go on. And what we see with that policy approach is a continuity. Whatever drama may happen from election to election, whatever sector-specific things may happen as economic conditions change or recession comes and goes, there's been a focus on continuity. So this is the policy context in which we look at investor-state dispute settlement and what the TPP means as a type of free trade agreement for the Americas, because it's notable that while the agreement is called the Pacific Agreement, it includes Chile, Peru, Mexico, the U.S., and Canada, potentially in the future, other countries in the Western Hemisphere. So in the brief time we have, let me, with that policy and historical context, touch on three basic issues. First is whether these free trade agreements and investor-state dispute settlement facilitate and promote development and investment at all. I was in a similar debate here some years ago, sitting at the same table actually, and I remember the debate at that time centered on whether you could look at data a year after a free trade agreement passes and see an immediate spike in foreign and direct investment, and because the speaker posited you could not, therefore these treaties are not promoting development and investment. On that issue, I would disagree. I would disagree at a fundamental policy level, which is that when you see in the policy and historical context that I mentioned that free trade agreements are a long-term commitment to the rule of law, a long-term commitment to cooperation and harmonization on the economic and investment front, and in that sense, reliability, security, and stability are a magnet for investment. And I would also argue that you can see this in specific investment decisions that have been made over time. And I'll just give one example, because I often hear no company ever makes any decision to invest based on these treaties. That is false. It is an utter falsehood. However, you cannot go into corporate rooms or ministries and know every decision that's made along the way, but I'll give you one concrete example. The Quito International Airport was inaugurated 3 years ago. It was inaugurated only after a quite dramatic disruption that occurred in 2009 through an expropriatory ruling of the new Ecuador Constitutional Court. Ultimately, the concession in question was renegotiated, and the investor group, including the lender group, the Inter-American Development Bank, OPIC, EXIM, Export Development Canada, as well as investors from different countries, required continued access to investor protections and investment arbitration in order to proceed with that project under the circumstances in Ecuador. The project resumed. It has had a 10,000 job impact and created a satellite city outside of Quito with significant long-term impact. Second question. In the process of protecting or promoting development and investment, do free trade agreements and investor-state dispute systems harm environment and labor and other things that we hold dear to our economic system, and understanding the importance of balancing economic growth with protecting our people and protecting our environment? Here, the record is mixed. It's mixed because there's a lot of attention on specific cases and what they may reflect in terms of a chilling effect on the capacity of a government to regulate, et cetera. But I think that we have to look at two things in counterbalance as in respect to this ongoing issue of how to juggle sustainable development in the context of free trade agreements. One is that, do you prefer to have conversations about the environment and labor with fellow treaty partners in a rule-based environment or not? Because what occurs now already under existing free trade agreements is a significant level of consultation between the U.S. government and other governments in the region and other governments among themselves with respect to environmental and labor issues. And so absent free trade agreement and the TPP, what are we left with? We're left without a context, even a procedural mechanism to facilitate those kind of consultations and facilitate long-term harmonization. So if I were to look at, I'll stick with Ecuador since I just mentioned that, would I rather see a world in which Peru, Chile, Mexico, Canada, and the U.S. have a broader context framework for discussing those issues or not. Ecuador is discussing those issues with China right now. That's our point of comparison. Finally, I discussed whether these treaties can promote development, whether they can protect environment and labor, or at least minimize harm of economic change. And finally, can the investor-state mechanisms protect procedural fairness? Now, it's a very long debate in terms of whether investor-state arbitration is a fair process or not. But let's just, as a brief focus, look at the results in the Americas. What you see in the Americas is that Peru, Chile, Mexico, the potential parties to the TPP, have had relatively fewer cases brought against them over the past 2 decades, and they've had significantly better results than most states. If you look to Bolivia, Ecuador, Venezuela, Argentina, for some different sets of reasons, you've seen more cases brought against them, more cases lost, and that relates, I would say, not to the procedure, but to the conduct and to the specifics of how particular cases worked out. Just in the case of Peru, Peru has had a total of about 14 cases before the International Center for the Settlement of Investment Disputes at the World Bank, and it has had a broadly successful record. As a matter of fact, Peru has had around $50 billion in claims brought against it, and the results so far are awards of over $100 million in favor of Peru. So if you tally up all the claims, you tally up the results, Peru has achieved more than lost in those cases. And even if you look more objectively at the results of different cases, you see states win cases, investors win cases, and, in another promising note, states and investors find ways to resolve their cases because of the procedural context of free trade agreements and investment arbitration. At the end of the day, we have to look at free trade agreements as well as investor-state dispute settlement against what existed before, which was a world without these kind of frameworks in place. And for investment arbitration, being in a world where things are all done through politics and letters from Capitol Hill is not an optimal world to live in. Thank you very much. I have many other diverse views on all of these things.
Thank you.
Pro and con, we'll save it for later.
Thank you very, very much, Jonathan. Thanks for getting us off to a great start and putting and framing the issue very, very well. Appreciate it. Clara?
Sure. So before I begin, I should state that I come to this discussion in favor of providing greater protection for state policymaking while still allowing for protection of investments. The reason I come with this perspective, as Michael said, I have been counsel to Uruguay in the case brought against it by Philip Morris before the International Center for the Settlement of Investment Disputes, or ICSID, challenging its tobacco control policies. My firm also represents El Salvador in another ICSID case brought against it by a Pacific Rim, a mining company that is challenging the state's policy to discontinue authorizing mining permits following a critical accident that caused a severe clean water crisis in the country. So as you can see, I do come to this with somewhat of a distinct perspective. Overall, is the TPP the great step forward, great leap forward? It's certainly not a great leap. It may perhaps be a step forward, but more than one step is needed, I would say, to respond to some of the criticisms that have been lodged against the investor-state dispute settlement system, or ISDS. ISDS has been a very fruitful and productive process and can help bring closure to major disputes where otherwise closure perhaps wouldn't be available. But there are flaws in the system that do now, after several decades, have to be corrected. So with the time allowed, I'm going to focus on the 5 of the main criticisms that have been made against ISDS and answer the question as to whether the TPP has responded to those criticisms. As I said, the TPP is a step forward, not a leap. It builds fundamentally on the existing treaty policy making and builds on the existing treaty models, and specifically on the U.S. treaty models. One study shows that something around 80% of the TPP's text in the investment chapter is built on the U.S. Columbia bit, and the language is also extremely similar and relevant to the Latin American context. It's extremely similar to CAFTA. So it builds on what was already there and perhaps moves the ball forward, but not far enough, as I'm about to discuss. So the main criticism, I would say, is that ISDS limits, to some extent, a state's right to regulate in the public interest. There are many examples of this. In the public health realm, of course, there's the case against Uruguay and another case against Australia with their tobacco control policies. In the environment, there's the case against El Salvador and many others that I've just mentioned, challenging the state's environmental controls. Many have been lodging with Canada as well. And then there are challenges against general policy making. For example, there have been a series of recent cases brought against Spain for its policies following the financial crisis of reverting their subsidies for renewable energy. So does the TPP help protect the state's policymaking abilities? There is a provision specifically relating to this, Article 9.15, which underscores the states, that states retain the right to regulate, particularly regarding the environment and health, but it does not actually protect it. It's made toothless by the clause that says, quote, nothing shall be construed to prevent measures otherwise consistent with this chapter. What that means is that any measure will still have to be reviewed and considered as to whether it violates or not the other provisions of the chapter. That language does nothing to change the review under ISDS. So in the end, it's welcome language, but it's mostly, I would argue, laudatory. There is a much more binding and forceful exception and multiple exceptions built into the TPP. For example, there is the incorporation of the GATT 20 article, which is a general exception relating to measures necessary to protect human, animal, or plant life or health. But it does not apply to the investment chapter. It does not apply to ISDS. So it's interesting that the states chose to put in a much stronger general exception, which would have provided greater protections for state policymaking in these areas, but specifically excluded it from applying to the ISDS. Instead, what we have in ISDS is some language moving forward, but it's new language. It's ambiguous, it's novel, so therefore it's open to interpretation. And as I'll address next, one of the other concerns is that tribunals over time have offered very broad and flexible interpretations of language, and this language allows itself to the same broad interpretation. It also deviates from the majority of other treaties recently signed by the parties where there have been similar exceptions put in. And the states, as I said, did carve out other areas, very specifically saying that the ISDS or the treaty protections didn't apply to specific areas, specifically taxes, national security, measures taken in times of financial crisis, and happily, as counsel to Uruguay, there is an exception for tobacco control measures, that tobacco control measures cannot be challenged in ISDS. Having said that, there are, as I said, steps forward. I was very happy to see in Annex 9 a better definition of indirect expropriation. There are two kinds of expropriation, and expropriation is one of the most commonly brought claims in ISDS. There's direct expropriation where a state directly takes property through nationalization, for example. And there's indirect expropriation where a state regulation may deprive a property of value to the extent that it's equivalent to as if it had been actually taken. So it's a deprivation of economic value through a policy. And as you can imagine, indirect expropriation allows itself to broad interpretation and application. And in the TPP annex, what we see is that it codifies the police powers doctrine, which already existed in public international law, which says that non-discriminatory regulatory action designed to protect, quote, legitimate public welfare objectives, such as public health, safety, and environment, do not constitute indirect expropriation except in rare circumstances. So you cannot claim that a tobacco control regulation which deprives your tobacco products of value constitutes expropriation that you should be compensated for. There's still you could still move this forward. There's still a flaw. It does not define more narrowly the use of non-discrimination to discrimination based on nationality. Some tribunals have interpreted discrimination to mean simply disparate treatment. If one investor is treated differently than another, that could be understood by some tribunals as discrimination. The other very welcome advancement is in Article 9.28, which is a restriction on damages, that a tribunal can only order a state to provide monetary compensation, monetary damages, if they're found to have violated the treaty, and makes clear that tribunals do not have the power to order a state to retract its policies, to revoke its laws that it has already put into place. For example, in the case Philip Morris brought against Uruguay, one of the requests is that the tribunal order the state of Uruguay to revoke its tobacco control measures. And of course, there are entirely separate chapters on labor and the environment. I won't get into those because we're here to talk about ISDS, and those chapters only provide for state-to-state dispute settlement mechanisms. The second main complaint is, as I mentioned, that there have been, in many instances, broad and flexible interpretation of standards by tribunals. And you see this specifically in the context of fair and equitable treatment. Fair and equitable treatment is a claim brought in almost every single ISDS case. It is not further defined within the treaties. So the tribunals have come up with a variety of understandings of what fair and equitable treatment means, which can be broad and can be narrow. The TPP makes a step forward, small one, by saying that it, quote, includes denial of justice. But all that means is that FET, or fair and equitable treatment, goes beyond a denial of justice. So it doesn't really provide greater clarity of where that scope ends. It also takes a step forward of specifically and expressly linking FET to the customary international law minimum standard of treatment, but many tribunals have given a flexible interpretation to even that standard. So it, again, is a step forward, but the scope of FET is still not clearly defined. What it could have done and did not do is list what would constitute an obligation under FET, what would constitute a violation under FET, which would give a very clear understanding of what the states consider that to mean. It also takes a step forward by establishing that interference with an investor's legitimate expectations will not on its own constitute a violation of FET. So if an investor thought that they were going to be able to run their business in a certain way and that expectation was not met, they could sue. And TPP clearly states that that is not a sole basis for violating the FET. But this language is somewhat similar to what's in CAFTA, and what we've seen is that in CAFTA, 6 of the 7 parties, including the United States, have said that legitimate expectations is not an element in FET. But in the TPP, you see that it still remains a element, a factor. It just can't be the only one. So they could have gone further, and they chose not to. And finally, they've added, two more. They've added a provision that it is the claimant's burden to prove their claims. And that welcome language, yes, but frankly, it changes very little. This is already a fundamental principle of international law that a party must prove its own allegations. So it's good that they're reminding the tribunals of the fundamental principles of law, but it doesn't do much to change the current situation. And another very, very welcome measure is that it creates a ability for a binding interpretation by the committee of the treaty so that they can give a binding understanding that tribunals must follow of what FET means if they decide to do so, of what any of the provisions of the treaty mean, which is a very important step forward. In NAFTA, there's a possibility for states to interpret the meaning of the treaty, and frankly, a state can do that in, two states can agree to do that in any treaty, but the fact that this has been made expressly binding on the tribunal is very welcome. The third complaint.
Clara, we're going to have to.
These are much shorter than the
please,
first two.
Please, we're going to have to get to.
Broad. Is that there's a lack of state ability to raise counterclaims against the investors. Here, the TPP expressly provides for that ability, but it's limited to investment agreements and authorizations, not to TPP violations. And some would say that that ability already existed under the current system under international law. The fourth concern is that there are limited controls on arbitrator conflict of interest. Again, a welcome provision under Article 9.21. That there will be standards coming forward on how to, on providing standards for arbitrator conflicts of interest and conduct, but it kicked the can down the road. Hopefully the parties will comply with the deadline to come up with these standards before the treaty enters into force. And last but not least, the fifth criticism is that there's no appeal. And therefore limited accountability for tribunal decisions, and the TPP really has nothing new on this, addressing this concern. I want to close, lest you think it's all bad news and it's doom and gloom in the TPP. I also have a list of my top 10 provisions in the TPP, but obviously, given the time allowed, I can't go into that. But I'm happy to discuss it in the question and answer.
Thank you very, very much, Clara. That was great. Melissa, we'll finish with you. Step forward, leap forward.
Wonderful. Thank you so much. So just one minor clarification. I do work in the People, Land, and Resources program, but the director of the program is Carla Garcia, who is sitting right here.
Okay, sorry.
Okay. No, that's fine. I just wanted to clarify. So you would have thought Clara and I had coordinated because I have a number of very similar points on the TPP provisions, but that allows me to focus my talk more on looking at sort of general concerns and some alternatives that the TPP could have taken but didn't. And so, although there are these so-called safeguards within the ISDS provisions of the TPP, the provisions will still have these negative impacts that we've seen on governments and people and the environment, and benefit overwhelmingly the investors. So, I think I'll talk first about those concerns before touching upon just a few additional points with regard to the TPP text. And I think it's useful to think about some of those questions that Michael posed at the beginning. What's the context of ISDS? Why was it created, and is it a model that continues to make sense in the world that we're living in now? It was a provision that companies from Europe were overwhelmingly asking for in investing in former colonies in Asia and Africa after World War II. And eventually they got these protections against expropriation in situations where they felt that they wouldn't have sufficient recourse in national courts. But what emerged as a very specific solution to a very specific problem has become one of the most ubiquitous provisions in international investment and trade agreements. We see it in more than 3,000 agreements, and over the past 2 decades, ISDS has become one of the most used provisions in these treaties. So, we see that the continuation of an inclusion of ISDS in these agreements provides this additional level of recourse for investors that's neither equitable nor necessary at this point. National legal systems have improved, but foreign investors remain the only entities that have access to this recourse. Moreover, of the publicly known claims, about 3/4 have been brought by investors from the U.S. and EU, and 3/4 of the claims have been brought against developing countries and countries with economies in transition. So the overwhelming use of ISDS by rich investors has really undermined countries' efforts to level the playing field by enacting laws to protect the environment and their citizens. If that's seen as an expropriation and indirect expropriation, as Clara described. So additionally, as has been mentioned, these cases can be extremely costly. The awards aren't all publicly available, of course, because many of them are private, but the average was nearly 17 million, but there have been some awards that are over 1 billion, such as the Occidental case that was recently revised, and lawyers' fees often average $8 million per claim. So, although ISDS is the dominant model for conflicts related to investment, countries and citizens along the political spectrum are increasingly realizing that this is a model that needs to change. Not just minor tweaks, but significant changes in how we approach this issue. The TPP's inclusion of ISDS was driven, as was mentioned, by the U.S. and the text that the U.S. has used in previous agreements, and it's really a missed opportunity to either create or build upon alternative approaches that protect not only investors, but also governments and the people they represent. Because conflicts related to investment, they very often involve the rights of others. As is mentioned, in El Salvador, the Pacific Rim case, contests the actions of the government to try to protect people from contaminated water, and experiences broad public support, and the fact that the system creates a recourse for the investor, but not for those affected, not for the government. It's a serious misstep, and it's not in line with the direction of policy that we should be taking. So I'll, in the few minutes I have remaining, we'll talk a little bit about some of these alternative models that we're starting to see. Brazil has developed the Cooperation and Investment Facilitation Agreement, which excludes ISDS altogether in its most recent agreements with a number of countries. So unlike most investment treaties or free trade agreements with investment provisions, this model doesn't include articles on expropriation or non-discrimination or the free transfer of capital. So instead of investors bringing claims, it's state-to-state consultations and negotiations are required. There's significant potential for this cooperative approach to promote more balanced and sustainable development, and we've also seen that India has taken, approaches similar to this, and that also includes substantive obligations for investors. So it's not just what does the state have to give to the investor, but rather in the investor bringing, investing in a country and engaging with that country, they also have obligations. So we've also seen that a number of countries have been returning to the requirement that all claimants, including foreign investors, first exhaust domestic remedies before bringing cases to through ISDS, and that's been seen in India's BIT model and several EU treaties, as well as in South Africa and Australia. They're seeking to strengthen the domestic judicial system so that international forums can be avoided. And Australia has also focused on the potential for state-to-state dispute settlement to be able to replace ISDS, although not within the TPP, as we've seen. And a number of other states have proposed a range of dispute prevention and avoidance mechanisms to be able to minimize conflicts before reaching that dispute phase, and exploring other dispute resolution at the national level. So I'm also happy to talk in more detail about the provisions specific to the TPP and how they may or may not address some of the concerns, but for now, I'll leave it at that.
Thank you. Thank you very, very much, Melissa. Well, thank you to all for excellent presentations. I think there are a lot of issues out there, and we can now open it up for your questions and comments. Don't feel like you have to disguise your comment as a question. But please be brief and just tell us who you are, and we'll try to collect as many as we can so we can get a good, rich exchange on these issues. Why don't we start with you, and then we'll collect a few. We'll come back to you.
Todd Tucker, University of Cambridge. I'm going to ask a somewhat provocative question, which is, should anyone besides lawyers care about any of this? It seems like the clients that Jonathan was talking about have had very limited success in actually claiming much of the damage that they were owed. So as political risk insurance, it doesn't seem to work very effectively. But then also your clients, Uruguay and El Salvador, there hasn't been a regulation that's been rolled back. There's just been litigation proceedings that have happened after the regulation took place. So I'm just wondering if, as a social scientist, I'm curious about real-world behavior. Are market actors responding differently? Are governments regulating differently, or is this just kind of a legal sideshow?
Thank you for that question. Yeah, please.
My name is Bjorn Arp from American University, and I also have my own firm here in Washington. My question is to Jonathan. Because I'm worried about the situation in Latin America in general, it seems that the TPP may be contributing to further strengthening the development of Chile and Peru in particular. Do you think that it will even further the strong diversities or differences, economic differences in Latin America, or do you think that this TPP may contribute to open doors to further development in the whole of Latin America?
Thank you. Why don't we start with those two maybe, and Jonathan, you can respond to the last question and also the other question, and if you want to respond to what's been said by Clara and Melissa as well, this is your opportunity.
All right. Just a short list of issues. The first thing that I want to respond to is the question of, is this all just a sideshow for the benefit of lawyers. Thank God for lawyers, because the rule of law and having states that are bound by rules and systems means that you have a robust need for lawyers. To me, I'm happy if we have in the Western Hemisphere a world in which lawyers in Peru and Chile and Mexico and Ecuador and other countries have to collaborate and find a way to structure deals, manage risk, etc. When you are making decisions, take the lawyers out of the equation. You're a state policymaker in a Ministry of Economy or in a Ministry of Energy, and you have to make decisions. How are we going to develop the natural resources in our country? How are we going to ensure that the people in our country benefit? How do we need to have opportunities for investors to come in, put money in that benefits our country, benefits our people, and gives them a way to make a profit, of course? Those are the kind of questions that inevitably have lawyers servicing them, but they are fundamental policy questions. And if you look at the role of these treaties today, yes, I would say that policymakers make decisions in certain ways because they want to encourage and nurture stability, and they want lawyers to help them do that. If you're an investor, you need to make hard decisions about putting money into country A versus country B and what that means to you 1 year, 5 years, 10 years, 30 years down the line. That too involves lawyers. If you're a bank and you're going to finance a $1 billion infrastructure project which otherwise will not be built, there will not be roads, there will not be a new airport, there will not be a new energy grid. How are you going to make the decision to structure that risk? So those are the real questions that are being decided by policymakers in states, by companies, by multilaterals, by lenders. All of these things certainly taking into account environmental issues and human impact. So in terms of the lawyers, God bless us, everyone. With respect to the other question that you raised, does the TPP create the risk of, effectively your question goes to an economic divide or economic inequality. In the Latin American context, one of the ways it's been raised, including by the dialogue, I think, is do you create, by having a TPP that Peru, Chile, Mexico are part of, but Central American countries are not a part of, are you creating a divide? Are you creating a bigger divide? Are you creating a short-term impact over the next 5 to 10 years in terms of what it means for economic growth, development, even immigration issues? My answer on this front is that I think that when countries, policymakers, and from what I see right now, the people of Argentina look and they say, do I want to be part of a movement towards a rule-based system that involves countries like Japan and Canada and Mexico and Chile or Peru? Or do I want to go do something different? Because the real divide, and I understand and I'm very sensitive to, and I'm dealing with fundamental issues of environmental and labor issues on investment arbitration, but fundamentally the big debates over investment arbitration in the past 10 years, 15 years since it began to be used in the region, don't go to whether Venezuela was trying to legitimately regulate and protect the environment. It's because Venezuela changed everything and went around and nationalized things that it wanted to nationalize. Previously, there was no mechanism for that. There is now. And I think history is already starting to show us the way that having a system for dealing with those things can play out. And I think it's also a positive sign if you look at Bolivia and Ecuador, for instance. Those governments today are a little different than they were in 2009. They see that public-private cooperation is important. And I think this system is part of the reason that looking for a more stable approach, maybe than a more erratic approach, has taken hold. So my answer is I view it more of the open door approach, as you said, which is It's something for more to get involved with, and I think it should be a priority if the TPP is ratified, that there is a broadening of Western Hemisphere participation in it going forward. Thank you.
Thank you. Claire, you want to defend lawyers too? Or,
I don't want to defend lawyers only. I'd like to defend the people of this planet. Because I think that the question from the gentleman from the University of Cambridge is a very legitimate and a very important question that many people have answered, and I would answer with a resounding yes. Should anyone but lawyers care? Absolutely. And you were asking for very concrete, I can't make eye contact. There you are. Yeah. You were asking for very concrete examples. Why should I care? What's the real world consequence beyond legalese? And I should apologize if I gave the impression that it's all legalese from my discussion. Giving a concrete example in tobacco control, what we have seen is that now the tobacco industry has found that bringing cases against states in the international sphere is a very forceful way to make states reconsider they're moving forward with their tobacco control policy. The states are comfortable and familiar with litigation in their national courts. They've done it many times, and it's terrain they understand. When a multi-billion-dollar company comes to the states which most need tobacco control, which are developing countries, and say we will bring a multi-million-dollar suit in a very unfamiliar and frightening plane, if you do not reconsider these tobacco control regulations, which, by the way, are often very politically difficult to accomplish regardless. What we've seen is that, yes, there is a chilling effect that states who do not have the resources, the capacity, the knowledge to take on a multi-billion-dollar tobacco company in international arbitration have decided not to move forward with their tobacco control policy, which affects the lives of thousands, millions of people around the world. And that's just one very specific area. It has consequences in many other realms.
Thank you. Melissa, you have any thoughts?
Yeah, just briefly, I would add that, past cases have, in fact, changed the practice of countries with respect to the environment. And that's part of why we're seeing these minor tweaks and language that says, oh, this doesn't infringe upon a state's ability to regulate in the public interest, even though, as we've seen, it may not go far enough to actually protecting that ability of states. But, we're seeing, as has been mentioned in the Pacific Rim case, that the government is seeking a very legitimate public policy objective of not issuing new mining licenses and not allowing for exploration because of contaminated water, because of the effects on people. And that's, they're having to defend that. It's first, was within CAFTA, and then because of the situation of the investor, they were seen as not qualifying for that, but the dispute continues, and it's certainly an open question of whether the government will be able to protect the people and the environment in the way that it has chosen and evaluated and decided is the best way.
Great. Thank you. We have another round of questions, Diana and Jim, and then we'll have Marilisa. Oh, we have lots of them now. People are waking up. This is
Diana Negroponte from the Woodrow Wilson Institute. My question's for Clara. Clara, you have emphasized the need for lawyers and the importance also of the agreement on a broader frame for citizens. I want to bring you to the practical case of the senator from North Carolina who has an objection to TPP based on the exception in tobacco. What mechanism might exist whereby partial satisfaction is given to him and the growers of tobacco in North Carolina in order to prevent the senator from putting a hold on this treaty?
Thank you. Jim, we're on right here. Jim.
Thanks very much, Jim Roberts, Heritage Foundation. Thanks to the panel. Excellent discussion. And I brought along a paper we've done on ISDS. If you can find it online if there are no more copies, where we make many of these same points in favor of ISDS provisions, minimum standards of treatment, due process, non-discrimination, expropriation. And we cite the U.S. Fifth Amendment, really, that's what essentially ISDS codifies, which is no person shall be deprived of property without due process, nor shall private property be taken for public use without just compensation. And that's really the essence of ISDS, I think. And we also note in our paper that of the 514 ISDS-type mechanisms used as of the end of 2012 in a UNDP study, 109 of them, 20% were filed against authoritarian or autocratic regimes in Argentina, Venezuela, and Ecuador. So I would just, and just to respond a little bit to some of the points made, I would say reliance on domestic law, maybe the epic fail case in recent years has been Chevron in the Ecuador situation. And overall, ISDS to us makes more sense now than ever, especially in a multilateral setting where you don't just have a bilateral where you might be able to work out conditions with one set of courts, but not 12. Thanks very much.
Thanks. Eduardo, Ambassador, our friend Ambassador Ferrero.
A comment. I will try to be brief and then a question.
Eduardo Ferrero.
Let me excuse myself to tell you my personal experience. When I was ambassador to Peru, to the States from Peru, I worked for the FTA between Peru and the States. One of our main problems was the pressure of private companies to Congress, American Congress, against our country, trying to avoid the FTA. It was a very big problem. We found a way to solve that. Now, after that, I was counsel for Peru with Jonathan Hamilton as co-counsel for Chico Lawson with White and Case. And I saw several cases. We were lucky. We make a good job. 12 of 14 cases have been completely in favor of Peru. I defended Peru. So now we have a mechanism to solve the dispute that we didn't have with the BITs and the free trade agreements. It is imperfect, of course. It must be improved, of course. But I wanted to make this comment to put a little balance on the situation.
Great.
No? That's my question. What are the main differences between an FTA typical, for instance, Peru and the States, and the TPP provisions on investment disputes? Thank you.
Thank you. Let's get a journalist perspective here. Thank you, Eduardo. Maria Luisa?
Thank you, Michael. Well, Ambassador Ferrero almost stole my question. I have another one for Jonathan Hamilton and for both of you, too, if you want to comment. And
Maria Luisa is from the Radio Programas, right?
I am the Washington correspondent for RPP Noticias, Radio Programas del Perú.
Okay.
And my question is regarding the situation currently of population in the area of La Orilla in Peru. And I know lawyers cannot comment on public of specific situations of cases that are brought to CIADI, but I would like to know, in general terms, how long does it take for a case like this to be resolved? How much time does a population in a remote area in Latin America has to wait for justice? What are the steps? And why, in this case, the population also decided to have representatives and lawyers in the U.S. to resolve the case, not only in CIADI, but in a federal court system? Thank you.
Okay, thank you. I'm going to ask the panelists to respond briefly. I know we have some other questions, and we'll get to them after a brief response. You want to start off, Jonathan? Or why don't you start?
Since,
why don't you start?
Okay.
Why don't you start? Lisa, then Clara, and then John.
No, I think
Yeah.
Okay.
Yeah.
All right. Great.
Any responses? Then we'll go this
Certainly.
way.
So I think in terms of the question about ISDS and it being more needed today than ever, it's certainly apparent that we need systems for solving and resolving conflicts. But we question whether this is the best approach. And there are some minor changes in the TPP that go slight way to addressing some of these concerns, but they don't really go far enough because they still have that overwhelming perspective and protection for the investor. So I think, a number of countries are starting to consider alternative approaches, and this would have been a good opportunity to do so. And then in terms of the question on the major changes between the U.S. Previous agreements, U.S.-Peru, and the TPP in terms of investment, Clara has already mentioned quite a few of them. There are some additional provisions related to public participation. So, the TPP says that ISDS panels should conduct hearings open to the public, and that and this next provision is similar to some that public interest groups can submit amicus briefs, as we've seen in some texts. So that's not a significant change. But panels conducting hearings open to the public has been in some treaties previously, but not in others. So that's one provision that has differed to some degree. And then in terms of, I don't think I have any additionals on the minimum standard of treatment or national treatment issues.
Okay.
I'll leave it at
Great. Thanks. Claire, you want to respond?
In response to the question from Mrs. Negroponte, I'm not involved in the politics of how this is all going to move forward and have no particular insights into U.S. politics and the approval of the TPP. But having said that, how to satisfy the senator's concerns, I think he would be satisfied if the exclusion was removed from the treaty. I don't know, because I'm not involved in the discussions, if anything less than that would satisfy him. I do know that the U.S. put a lot of thought and consideration into putting in place a provision that would satisfy a lot of the concerns of the domestic constituencies. And for example, there is a provision in the exclusion that it applies to tobacco products and not to the tobacco leaves themselves. The United States is mostly a provider of the raw materials, which are then made into the final products of cigarettes elsewhere. So that has already gone a long way to appease the tobacco farmers, for example, which are producing these crops. What more he would want, only he can say. In response to the question of the main differences with the U.S.-Peru FTA, I highlighted what I think are some of the unique advancements that we've seen in the TPP. I have not specifically compared it to the U.S.-Peru FTA. There are many differences. The transparency provisions are something relatively new, although it does exist elsewhere, as is the ability to have expedited review and dismissal of claims that are, quote, manifestly without legal merit. So that's a new advancement, which I think is welcome, although it does exist in ICSID and other institutions that already are out there. And then how long does a typical case last? It varies tremendously, but I would say, I was comparing with Jonathan, I would say the average might be around 4 years, but it really depends on which people often raise an eyebrow to, but domestic cases often last that long as well. That litigation takes time if you want to do it properly. And it also depends if the respondent challenges jurisdiction and whether that's a separate phase from the review of the claims themselves, which can expand the length of the case. So it can go from 2 years on upwards. The Uruguay case, which recently finished in October, took 5 years. There was 2 separate phases on jurisdiction and the merits as one example.
Thanks. Jonathan?
Okay, I will touch on a few of the different issues. One is a fundamental concept about economic freedom. There's something called the Index of Economic Freedom, and you can look at different Latin American countries and how they rank on this scale. Now, one can argue, is this a useful scale or not, but fundamentally, what you can see by looking at data on economic freedom is how it has been stable or not stable over the past quarter century. And what you see in Latin America is that in 1990, most countries in the region were red, not free. By the year 2000, most countries had become blue or trending blue. By the year 2010, you saw that certain countries, the TPP treaty partners, still blue. And you saw other countries had become red or some fascinating shade of purple that keeps us active and interested in other countries. And so that is the broad macroeconomic and policy framework in which all of these decisions are being discussed. And as Dr. Ferrero, Ambassador Ferrero mentioned, in the instance of Peru, for example, on balance, having such mechanisms versus a world in which no such mechanisms existed seems favorable because it creates a framework for discussing these investment policy issues that did not exist before. Because previously you ended up in a scenario, which some in Washington still try to use, which is we're going to do this through politics, lobbying, Capitol Hill. That is not the way you want to resolve your investment issues, strictly through political measures without a more rule-based system. And one only needs to look back to 1968 in Peru to see what the world is like when you don't have such rules. With respect to the length of proceedings, and also I was asked about La Arroya. Length of proceedings totally depends. I have represented states, investors, and I can tell you that efficiency issues are not something that treaty negotiators are going to be able to resolve, but lawyers can make a difference. For Peru, some of the fastest cases ever in World Bank arbitration were cases handled by Peru, where we made express procedural decisions and judgment calls along the way to try to do things in a more efficient way. And it comes down to very concrete decision-making, planning calendars, and things like that. And so we've done entire cases in 18 months, which is relatively efficient for cases of this magnitude, complexity, and the number of stakeholders involved. On the flip side, there are other cases that take a very long time for a lot of reasons, complexity, but with respect to La Arroya in particular, La Arroya in brief is a metallurgical facility in the Andes Mountains in Peru. It was effectively privatized in 1997 through the sale to an entity controlled by a U.S. investor. And there are issues related to liability for environmental contamination at that site. Environmental contamination that has affected citizens, children, workers, and the fate of that metallurgical facility. That proceeding is going to go on potentially for a very long time. It already has been going on for years because it is a live situation. Many times the disputes handled through investment arbitration are effectively historical situations where you're debating over something that's already occurred and who should pay whom or not related to those situations. La Arroya, and this is certainly the case in many regulatory related disputes, is a live situation. It's a situation in which environmental contamination is an active issue. It's a situation in which citizens and children born since the privatization of that facility have brought claims in U.S. courts against the U.S. investor and entities and individuals. They have brought claims before the Inter-American Commission saying that Peru didn't do enough to protect them. The investor has brought claims as the first dispute under the U.S.-Peru Free Trade Agreement, saying that Peru didn't do enough for the investor. And all of this is a live and active situation unfolding over time. What will be the fate of this facility? What will it mean for environmental cleanup? What will it mean for environmental compliance? What will it mean for those children? What will it mean for the investor? What will it mean for the long-term development of the sector in Peru? Far beyond what I can discuss in the next 10 seconds, but that is an example of something that really, to me, is at the heart of all of the issues that we're discussing here today. The only thing I would say is, if there were not ISDS, how would this problem be dealt with in today's world? That's a challenging question. That's a challenging question.
Thank you. We're going to go one more round. I'm sorry, we're going to end it at 10:30, but I know there are a few questions. We're going to collect as many as we can. Yes, why don't we start with you and then Joan, and then we go to the back. Please be very brief because the time is limited and we want to.
Thank you. Thank you. Carla Garcia Sendejas from CL, and I appreciate, Michael, for having this event here at the Inter-American Dialogue. As a citizen of Mexico and a lawyer which has focused and learned about NAFTA since I was in law school years ago, I would ask the panel and question you mentioned, Jonathan, the index of economic freedom. Today, the level of extractive industries and the investments in Latin America continue to grow, not just via foreign direct investment, but also multilateral development bank financing and Chinese and Brazilian, et cetera. And in the last years, we've seen a rise of conditions that are, as Melissa has mentioned already, environmental frameworks that have existed, that have been put in place to protect the environment, to protect communities, to protect environmental health, et cetera, but that continue to be questions. Environmental defenders continue to die at alarming numbers in Latin America and other places around the world. And countries are taking steps to protect investors. In Guatemala, even the threat of a potential case at an arbitration court made the Guatemalan government take some steps and some concessions on mining. In Mexico, we see the creation of the Gendarmería Nacional within the context of the energy sector reform, which basically is going to protect investors and not communities when their project faces some opposition from a community. So what do you say to that? When we see that, yes, we continue to see legal frameworks that continue to protect investor, and I'm not against development in any way, but when the level playing field does not seem to be as level as we would hope it to be.
Thank you. Joan? Joan Nelson here.
Joan Nelson, earlier of the Woodrow Wilson Center and AU, unaffiliated now. A question about the composition of the arbitration panels and how they're appointed. Clara mentioned very briefly, as time was closing in on her, that there's been some attention to conflict of interest. One might regard that as sort of a basic floor of criteria for selection. And is this an area for potential improvement and encouraging greater confidence in the process?
Thank you. Yes, please. There.
Hi, I'm Melinda St. Louis from Public Citizen. Thanks to the panelists. I just wanted to raise a couple of points of things that were raised, particularly around the encouragement or potential for encouragement for foreign direct investment under these treaties. There were a couple anecdotes thrown out there, but there have been empirical studies about this, and UNCTAD has in its latest report delivered a synopsis of the studies is that the results do not support the hypothesis that these treaties foster bilateral FDI, kind of when you look empirically. And it's also important to note that countries like Brazil in the region that have no ISDS enforced pacts are receiving the most FDI in the region. So I think that's important to take a look at. Some of the countries that have been terminating their treaties have not seen their FDI flows decline in that period either. So I think it's important to put that out there. And when the discussion about having discussions in a rules-based system, I think that makes sense when you're conflating the environmental and the labor chapters with ISDS. You could have that discussion, state-to-state dispute settlement on those issues in a TPP and without having ISDS. So I think that's important to note. And the rules themselves matter, as we know. I mean, they could have chosen to narrowly define the standards for expropriation. They could have chosen to have real carve-outs like they did for tobacco on some of these other issues. They know how to do that, and those choices were not made in the TPP. And so for that reason, I think it's important to make sure that the discussion includes those issues as well. Thanks.
Thanks very much. Yeah, final question, and then we're going to go back to the panel for a brief
Thank you.
reaction.
My name is Marcelo de Jesus. I'm an Argentine consultant. In the situations and cases that were described, apparently there are two interests involved. The interest of the well-being of the people and the well-being of the investors. Shouldn't be considered a third interest is the interest of the people who govern the state. Let's say, what do they get out of these deals? This probably should address the first round of questions is lawyers probably are not involved in those situations. In the second round, probably this interest has some impact in the time of the case, because while the case is being brought before the CIADI or any other organism, the state continue negotiations with the investors. So my question is, what about this third interest I'm talking about?
Thanks. We're going to, for time, we're going to have to go back to the panel for a quick reaction start with Melissa Coletta, and then final word, Jonathan.
Yeah, so just very quickly on that last point in terms of the interests of the government, that's certainly something that's really should be included. I think it's a system thinking about out of the ISDS system, what could come that recognizes various rights and interests of all parties affected. So, creating different systems for mediation to start with, what are the priorities of the government? How are the people affected? How has the investment been affected? Looking at all of these issues in one space rather than having an investment suit at ICSID and cases in U.S. courts and, at the Inter-American Commission, being able to at least discuss all of these different issues in the same space is certainly something that makes sense. And I think the other points I'll leave to the other panel.
Thanks, Melissa. Sarah?
On the question of creating a level playing field, I do think it's important that states should have an obligation to protect investments and promote development. That can be whether that's in treaties or in domestic law or any other mechanism that creates the rule of law. But I also think that those obligations need to be clear, they need to be defined, and they need to be done in a way that states know how they can conduct themselves and feel comfortable moving forward in their policymaking when it's necessary. And I think one thing that we saw and that I mentioned earlier is that there is a unilateral dimension to ISDS. It's investor state. It's the investors bringing claims against the states, and that's because these treaties create obligations for the state and not for the investor. And I do think that there is an opportunity for these treaties to create also obligations for the investors so that states can bring counterclaims or even claims of their own under the treaty. And one advancement we see in the TPP is that there is an article specifically related to corporate social responsibility. Does that article move forward as much as it should? Probably not, but it is there, and it, again, a step forward. That could advance and become something closer to an obligation so that states, we could have a more level playing field, and as much as states can bring legitimate claims against the government could bring legitimate, investors can bring claims against government, the governments could bring legitimate complaints against investors not fulfilling their end of the obligation. And then regarding arbitrator conflicts of interest, areas for improvement, I think one, I'll just name two off the top of my head. One is that in these, often the tribunals are 3 arbitrators in which the 2 other arbitrators must decide the fate of the third arbitrator that's being challenged. And those same arbitrators know that in the next case they themselves may be challenged, and that creates obvious tensions in their decision making. I think that there should be an independent person, body, whatever it may be, that decides these challenges so that the 2 other arbitrators who are going to have to work together with this arbitrator if they remain are not placed in this difficult situation. And secondly, right now it's common practice for arbitrators to also at the same time serve as counsel in other cases. So one day they may be sitting behind the bench deciding the fate of a certain provision or standard, and these standards repeat themselves throughout the cases. And the next day they're arguing very strongly and vehemently for a very specific position on that same standard. So it becomes difficult for them to be, have a real objective perspective and sit back and divorce themselves from their role as counsel. And one requirement I would recommend, but that's hotly debated, is that arbitrators should not also at the same time serve as counsel.
Great, thanks. Jonathan, final word.
There's so many issues. Feel free to register for my class at the University of Miami, read my book, look at my website on many of these issues, including a lot of the more procedural issues or arbitrator-oriented issues. Free trade agreements, including the TPP, raise very important issues about the capacity of governments to regulate and manage the environment. It's a very important issue. Senator Clinton has raised notable comments about this important issue, and we could debate and discuss over a long period of time. I think it's important to note that investors do have obligations under free trade agreements, and they will have obligations under a ratified TPP. A very long and carefully developed line of cases shows the obligation of investors to comply with applicable law, comply with local regulations, and that can have not only fundamental consequences for investor claims, but fatal consequences for their claims. I've done nothing for the past 20 years of my life except focus on this relationship between investment and dispute scenarios, in particular in Latin America, and there's a long and interesting line of cases related specifically to that. And so the relationship between investors, states, and the impact on communities and citizens and economic growth is really, in my view, what this is all about. Smart investors act in good faith, comply with regulations, understand that true long-term profit opportunity involves sustainable development, respect for communities, and respect for the environment. And what you see in many of the cases, and certainly in Peru's cases, is an emphasis on the responsibility of the state, yes, and also the responsibility of investors. Peru was the first Latin American state to bring a claim at the World Bank against a foreign investor, not because Peru was being anti-foreign investor, but because the foreign investor had expressly breached its concession obligations, unlike any other foreign investors. Peru filed a claim, and in the end, that investor paid the full amount of that claim in cash to Peru, which used existing investment arbitration mechanisms to enforce the laws of its country in a fair and transparent manner. And so there's some things that you can fix through treaty negotiation, and there's some things that require good faith and diligent efforts by states and by investors and by their lawyers and by NGOs and communities who are also stakeholders and participants in this entire system. And if you look as a general matter, there is a trend toward greater transparency. There is a trend toward greater intergovernmental comments and participation. You see it in the La Arroya matter, where there's a high degree of transparency. There's U.S. government participation in treaty interpretation issues. And so we've seen movement on some of the areas of greatest concern in this field. The fundamental issue about regulating the environment or public health, it's not going to go away, obviously, by this treaty. The treaty is only going to, if ratified, create a slightly different environment and more globalized environment for confronting those issues instead of being in a more bilateral framework as it's been in the past. Thank you very much.
Jonathan, thank you very much. Clara, thank you. Melissa, that was terrific. I think we've heard some really interesting perspectives. I want to thank our panelists for sharing their knowledge and their insights. I want to thank again my colleague Eric Brand for organizing the session, and I want to thank all of you for joining us this morning. A lot of new faces here. I hope you'll come back to the Inter-American Dialogue. We have lots of programs, and we'd love to have you participate and engage in our work. So thank you all very, very much for coming this morning. Thank you.
Good job.